Garfield, City Commission is now in session. The Honorable Christopher M. Murray, the Honorable Annika Ledica, the presiding Honorable Colleen A. O'Brien. All persons having business herein draw near, give attention and shall be heard. God save the United States, State of Michigan, the Honorable Court, please be seated.
Good morning. On behalf of my colleagues, Judge Ledica and Judge Murray and myself, we welcome you here today to our second day of case call in Lansing. I see many familiar faces, so I know you're familiar with our procedures, but for anyone that's new, please know that we're very familiar with your cases. We've completely reviewed them. Some of them we've already talked about with each other. So there's no need to repeat the facts. We're very familiar with the facts of your case. Please just highlight any issues that you believe are very important and why you believe you should prevail before the court today. I believe we may have some cases that involve minors, and please do not refer to them by their name. Please use their initials because these proceedings will be made available to the public. All right, thank you. With that, we will call the first matter, which is docket number 12, case number 370585, the estate of Humphrey versus Alternatives for Children and Families. Attorney?
Morning, may it please the court. Rob Kamenak. I represent the plaintiff appellant, which is the estate of O'Marion Humphrey. I know you're familiar with the facts. Just as a quick reminder, this is the case involving O'Marion Humphrey, 9-year-old, severely nonverbal autistic, who was placed in a foster home situation with a Ms. Richardson, and that was arranged by the defendant appellee, Alternatives, which is a company which sought and obtained a ruling of absolute social worker immunity from Judge Farah of the Genesee County Circuit Court. And that is, among other things, that's before the court today by way of the appeal. You know the facts. I know all of you, I understand at least 2 of you have experience in the family court, so you probably know more about this than I do. And I know, Judge Murray, you've had a couple decisions in this regard.
Which the last one of which answers the question, really. Talks about close supervision and what it was meant. And I mean, what else is there need? What else needs to be done?
I don't think anything else, but let me just make 3 or 4 comments and then I'll sit down. Okay. Let's also talk about timing here, because what happened is, Alternative is leaning on a hearing that took place on May 5th, 2015. And that's the first time there is any mention that I can see in the record about the foster parent or the foster home, not even identified by way of Richardson. The problem with this case is all the allegations relate to activities that took place before that time. So notwithstanding the lack of close judicial oversight, which I agree with, doesn't have it here, you really have a situation where somebody is trying to say that when the family court was approached, that somehow some scant review at that period of time, and it's in the record, somehow relates back to activities that were done earlier where there was no judicial review or close oversight and cloaks Alternative with immunity. That just doesn't make any sense, let alone blanket absolute.
Why doesn't that make any sense? Because I mean, like in the context of like governmental immunity, the government hires an employee years earlier, and then all of a sudden they do an act that is alleged to be grossly negligent. Well, you still get immunity, even though maybe you shouldn't have hired the person way back when, or you didn't give them enough training. You still are cloaked with the immunity because you have the immunity for the act that was at issue.
But here, my understanding of the case law, including Martin, is such that the only reason you would get the immunity, if at all, is because you were, in essence, part of the family court. You either testified, provided a recommendation, or the like. Right. And until that happens, well, I don't. I understand your point.
You're trying to. I mean, I know what you're trying to do. Obviously, you need to, but well, it doesn't. You know, the lawsuit occurred because of things that occurred while the child was under the supervision of, the foster parent. And you're trying to then draw back to, well, way back before they were working for the court, they weren't instituting proper training and supervision or whatever, right?
Right, right. But the immunity applies when you're involved with the judicial system in your activities with respect to the judicial system. And those activities that happened earlier were not related to the judicial activity. So maybe we're addressing that, maybe I'm addressing it, if I may, Your Honor, just in two different directions at the same point. And so acknowledged. So again, it sounds like the court is fully familiar with my position. I don't know if the court has questions for me on our position. Let me just say that I do believe, 2 points. I do believe that what Judge Farah did is he did what I would call the blanket absolute immunity. He talked about at one point in the transcript, looking at the status of alternatives as the basis for granting immunity rather than they were involved with the family court. And I don't think that's the proper way to look at it. I guess I'll save for rebuttal if there's any discussion about the Spikes case. Absolutely.
So
I'm here.
You would, that is why you're here. So there, Exhibit 16 to your brief is the affidavit of Richardson that was filed in the federal court action.
Correct.
Was that ever filed with the trial court in this action?
No.
So why, that would be an improper expansion of this, of the record.
Well,
It's
it
not-
would be, other than the fact that one of our arguments is that we weren't entitled to discovery. And again, just to remind the court, the case was filed in less than 4 months.
Oh, we saw the lengthy procedural history,
Okay,
right? And it stayed out there for a long time because
agree.
of the federal court proceedings. And then when those concluded, it came back, and I understand that this is, an appeal as of right from the final order, but yeah.
Well,
Very familiar with the lengthy procedural history.
and to answer your question directly, if I didn't already, and if I don't mean to wander, we did argue in the lower court, and it's in our brief as the last issue,
Mhm.
that we were denied discovery. And all I did is provide the court with something that happened while this case was still alive to demonstrate that there were facts that would have supported a Second Amendment complaint. That's all. All right? Any other questions?
You have time for rebuttal.
Thank you.
Thank you. Morning. Good morning. May it please the court, Julie Firschman appearing on behalf of the defendant appellee, Alternatives for Children and Families. I'm pleased to be here today. I'm pleased to be here because this is a case that I personally have lived with for some 10 years. It was 10 years ago that the trial court issued its summary disposition ruling, 10 years ago that the trial court denied reconsideration, denied leave to amend. Before I begin with the most important points, recognizing, of course, your familiarity with the case, I wanted to reaffirm and make clear that Michigan takes incredible attention, or it has incredible respect for the protection of children. There is no question about that, especially children who are accused of being victims of abuse and neglect. In those situations, when children are removed from their homes and they're put in foster care, the courts in Michigan have recognized that the private placement entities, such as my client, Alternatives for Children and Families, are entitled to and have received repeatedly absolute social worker immunity. All of that connects to the paramount importance of the protection of children. And that is, I believe, the overarching theme of Michigan and the way that our state looks to this immunity. And now I'd like to address, with that kind of background in mind, and of course, the cases that you have already read and are familiar with. There's Martin versus Children's Aid Society. There's the Spikes case, Spikes versus Banks. There's Buford versus Lewis, Judge Murray was involved in that case. But in the course of the briefing that you've read, plaintiff's counsel has challenged the entitlement to immunity, and I believe you can review the briefs and see the points that were made there. But there are some additional comments that I'd like to highlight for your attention. And one of them is the argument seems to suggest that giving places like Alternatives for Children and Families, these private placement entities, absolute social worker immunity is essentially a license to steal. It's a free pass. It's an opportunity to look the other way while horrible abuses occur. That is definitely not the case. I'd like to emphasize, and some of the court cases have already done that for us, that there are still remedies available to people who believe that the system has not worked, who believe that there is a problem with the methods in which the DHS, private placement entities, and even the courts have proceeded. What are they? Here are a few of them. And as you'll hear, the plaintiff estate availed themselves to some of these opportunities. And one of them, which is noted in the Martin case, is if you are an aggrieved parent, the Martin court noted, you can challenge the orders of the family court. You can appeal the orders of the family court. If you don't like what has gone on with, of course, the private placement entities integral to the process, you can use the court system to challenge. Next is you can sue, if you wish, the at-fault foster parent. In this case, as you are all aware, we have Lazenette Richardson, who was approved by Alternatives for Children and Families, who accepted this assignment, but only a couple of months into the assignment fell asleep on the job. The plaintiff estate has sued her. Oddly, not totally relevant to the issue of immunity. In the course of the case, plaintiff's counsel took their time, never even addressing, never even litigating actively Ms. Richardson. Instead, the case went on into different angles. And one of them is another remedy that's available to aggrieved parties. And that is, if you would like, you can sue individuals with the state of Michigan. And that is exactly what this estate did. They sued individual employees of the Department of Human Services, collecting a handsome sum for that matter. They are very well aware that is another remedy available, even with the existence of immunities. And then there's something else, although not mentioned in the briefing, that I'd like to highlight, because it was noted that a couple of you sitting here today have had experience in the family court, and that is the probate court statute allows an opportunity for parties to seek an accelerated review. That's in Michigan Compiled Law 712A.19. And it even says if you could make a motion if you are a party to a case, perhaps a family member, and you can ask the family court for an accelerated review of a matter if you think that there is need for closer watch. These are all examples of remedies available. And I would submit to you that these remedies also could do double time and serve as safeguards. In fact, it was even noted in the Martin case, the words of the court there on page 97, safeguards against misconduct were built into the adjudication process itself. These are remedies, these are safeguards, and they all exist even with the existence of the absolute social worker immunity. A couple of other points I'd like to explain that are not completely clear in the briefing that was submitted. The issue of close oversight. Essentially, the argument that the appellant, the plaintiff, is asserting today is this absolute immunity really does deserve to be scrutinized. We need to chip away at it. I suspect they're trying to tell you. They're trying to take away the absolute immunity and say it only applies in limited circumstances. But I'd like to address the foundation for this, the origin of even the concept of close oversight. It wasn't made clear in the briefing, but it did start from the Martin case, the case that you're very familiar with. It was in a footnote in the Martin case, and it was footnote 5. And it was a response by the court, from what I'm able to tell, from a comment in the dissent. And it was thrown into the case itself. And the court made a comment with the very language that the Michigan Supreme Court seized upon when it issued its opinion that it was not going to accept leave. And that was this. The court said in footnote 5, in Martin, that the ruling was limited to the facts of the case in which close oversight of the social worker's placement recommendation by the probate court is especially noteworthy. And that's noteworthy too, because you're familiar with the facts of Martin. Years passed from the time a child was taken from the child's family under the belief that the child was abused. And the parents wanted that child back in Martin. Years passed because they raised issues, the family members that is, of brittle bone syndrome that might have explained why the child was found with broken ribs, all sorts of bruising. Years passed, and the probate court refused, or the family court in Martin refused to restore parental custody. So there was mention about private placement oversight. Again, the Supreme Court, when confronted with the Martin case, declined to accept it and made that quote. But what does this mean, this close oversight? And is it really a red herring? Is it relevant? Well, I think Judge Murray can tell you, because he was one of the judges on the case that was the last case to address what this really meant. In fact, it might be the only case. In the case of Buford versus Lewis, the court seized on what this close oversight meant, because the plaintiff's attorney in Buford was making an argument that there needs to be, as the plaintiff argued, close monitoring of the social worker's conduct. The plaintiff argued in the Buford case, as Judge Murray knows well, that the court should monitor every discrete act of the social worker, everything. All of that was argued by the plaintiff as critical. This is necessary for immunity. But that's not how things ended up shaking out in the Buford case. In fact, the Court of Appeals, and I'm not going to read it to you, but it's on page 90, page 8 of the opinion, the court noted that they rejected that point. Close oversight did not require micromanaging, close scrutiny of every discrete act. In fact, the court noted that close oversight was referring to, and I'm quoting now, a situation in which the probate court had reviewed the defendant's social worker's findings.
But Ms. Frischman, I don't think that's what Mr. Kamenek's arguing. He's not arguing that there, at least I don't think he is, that there's more minutia in the oversight. He's saying what they're alleging as negligent acts occurred prior to your client and Richardson being involved with the court proceeding. And he's trying to get back to an earlier time and say, well, there shouldn't be any immunity because it was for things that occurred, decisions that were made, I guess, prior to the court proceeding where your client was involved. Or am I wrong on that?
Your Honor, my reading of where plaintiff's counsel is going with that argument takes us back perhaps to, in reference to what they were mentioning about actions before, perhaps before the time that Alternatives for Children and Families became involved. But rather, as I see it, the focus, if you're going to look at liability of a private social worker entity, you have to focus on what they've done. This is, of course, a case where the plaintiff has sued for negligence. They're saying that what we did, what Alternatives did, was negligent. How was it negligent? Well, it's in their complaint, their first amended complaint, and they argued that we should have scrutinized Ms. Richardson. We should have trained Ms. Richardson. I would submit to you that if they're going to make a claim against Alternatives for negligence, their point of their case has got to be during the relevant time when Alternatives was involved. On the other hand, if the plaintiff is arguing that the basis of their negligence case against Alternatives focuses on conduct and activities before Alternatives involvement, that would still, if they want to make a case against Alternative, come right back to Alternatives. Because maybe the point is Alternatives didn't turn things around. Alternatives didn't lift a stone to find things underneath it with respect to Ms. Richardson's history, her background, her training, or in this case, her experience with severely autistic children. The point being that if we're looking at the issue of liability of the social working entity, the close oversight issue for plaintiff's purposes has got to be, what did we do? And ultimately, going back to the issue of close oversight in the context of Martin, close oversight would refer to reports that Alternatives prepared to the court, the substance of those reports that were put in. Apparently, plaintiff's counsel disagrees. if alternatives had an assessment that the child needed to be placed. In this case, it was the whole family. Perhaps it's their concern that alternatives put the child with Richardson. Maybe their problem is alternatives should have stepped in a little bit more when Richardson had some concerns. What we're looking at then is plaintiff arguing this close oversight, and I'm not here making the argument for them, I'm simply addressing it. But their argument seems to be, Your Honor, that close oversight is a prerequisite for these immunities. But what, Your Honor, you and the panel in Buford said is that there is a process through which the court has proceedings. The court reviews documents before it. The court does this as part of the oversight process. And in this case, the oversight process, I'll take you back to the same statute, is mandated not by a court case of Buford, but mandated by MCL 712A 9.19. Talks about in the statute, and this is a statute that is followed in the process of assignments and removing children from their homes. The statute talks about the importance of a review hearing every 182 days after a placement. There's a process then where the court will be looking at the reports. The court will be asking questions. And that happened in this case actually twice. It didn't just happen in May, which was 2 months before this horrible incident occurred. It happened in February when a placement was made and a decision was made by the Oakland County Probate Court, Family Court, I believe, to remove Omarion and his siblings from the family, the Humphrey family. So we have a hearing, and my understanding from reading the file is that the Humphrey parents were present. So we have review, we have oversight, and I would submit to you, it is, if the court believes close oversight is an essential element to immunity, I'm not so sure that's what Martin says, it was met, because we have a hearing in February, and then we have a follow-up hearing in May 5th. Mind you, you've heard me reference the statute twice. The statute talks about review 180 some days after the placement. This review was only a couple of months, late February, early May. That even exceeded the statutory requirements. Mention was made, if I may shift gears for a moment, on leave to amend. The point of the trial court, I will submit to you, was looking at the nature of the duties of alternatives. As he said, the status of alternatives effectively made the decision for the judge. What do I mean? We know that plaintiffs sued for negligence, and we know from reading the Martin case, negligence cases are subject to the absolute social worker immunity. In terms of amendment, though, plaintiffs' counsel wanted to add a few things. He said he wanted to add breach of contract. He wanted to add violation of a Michigan statute, a child protection law. The difficulty here, and the reason I believe that the trial court got it right, is that Martin said all of those things, all of those claims are effectively dismissed. All of those claims are subject to the absolute social worker immunity. And in fact, in Martin, there were even more claims. There was negligence, breach of statutory duties, breach of contractual duties, bad faith, even violation of constitutional rights. Martin said, from the state court perspective, all of that is barred because of the immunity. Why? It's futile. The immunity makes all of those claims unnecessary. Plaintiffs' counsel also made an argument that there was a deprivation at the trial court level of discovery, with the hope, I suppose, they're attempting to say, the hope that if the trial court would have allowed additional discovery, maybe they could have pursued some additional digging into the close supervision element or anything else in the case. I wanted to only address a couple of things. My brief in response to that point says it all, in my opinion. But I'd like to clarify, when the statement is made that there was no discovery, or as mentioned today by Mr. Kamenek, not entitled to discovery, as he said it, the plaintiff was not entitled to it, we know that's not true, because there were 2 sets of discovery requests. There were at least 100 documents that were exchanged. There was discovery. And we also know, as my next point, that the court rules give counsel an opportunity under MCR 2.116H to address the court. if you truly believe you can't respond to a motion, you need facts, you need information. 2.116H permits counsel to put an affidavit together and say to the court, this is what I would like to accomplish, and this is why I can't do it now. Was that done here with respect to a close oversight issue? No. Was it done by counsel with respect to immunity issue? I submit to you the answer is no. It's an avenue that wasn't explored. So it's, in my opinion, disingenuous for counsel to assert in the briefing, trial court level and even now, discovery was deprived. It wasn't. But the next thing is that the judge doesn't need it. You're familiar with what Martin says and Spikes and also the Buford case. With immunity as it is, the court understood the role of alternatives, and alternatives motion for summary disposition laid it out. There was supervision by the court. Alternatives gave a couple of reports to the court, and the court acted on those different things. I'd like to get to another issue that wasn't, I believe, addressed in oral argument, but it was addressed at tremendous length in the briefing by plaintiff's counsel. And that's this argument of a functional approach that plaintiff, now appellant, is asking this court to adopt. And the point that they're making, I would submit to you, is to chip away yet again at the absolute social worker immunity by applying a standard that, as you read the cases, seems to apply in the federal court cases, but not in Michigan. Michigan, I believe, based on the point I made about the overarching concern about protection of children, doesn't allow exceptions, hasn't really applied a functional approach. The words I just said were hasn't really applied a functional approach, and here's what I mean by that. When you read plaintiff's brief, when they refer to the need for a functional approach and that immunity should be conditioned on the functional approach, as judges, you're probably looking to find what law do you have for that? What's the basis for that? But you won't find any law from the state
This
courts.
version, don't you think Buford's right on point?
I do believe Buford is on point.
Okay, we don't, I mean, I appreciate your efforts, but it's not as complicated, I don't think, as we need to go over all that.
Absolutely.
We've got binding case law. We're not gonna declare a conflict. It's discusses the whole test about close supervision and probably
I think you've
answers
stated,
the question, at least gives us the framework to decide the case.
yes, Your Honor, you saved me some argumentation time because the functional approach is nice in theory, but in practice, it defies cases, it defies the spirit of the law, and it defies common sense and our values that have been shown through repeated cases issued by this court. So with that, I would be happy to answer any questions. Obviously, you're very familiar with the essence, facts, and law of this case.
Thank you.
Thank you.
Famous last words, I will be brief, but I will be brief. Close judicial oversight. Let's think about those words. First of all, judicial. So you got to involve the court system. Two, let's talk about close. And this is the last point I have. This May order doesn't say much, to be honest with you. It just, they come out and say that, and I'll quote it and then I'll stop. It is also in the best interest of Lamarian Humphrey to remain in his current foster home until appropriate family member is considered. That's it. That's what they consider to be the close judicial oversight. That was, it took place on May 5th, I believe, of 2015. And as Judge Murray indicated, we're pointing to activities that happened before that time in any event. So it may be judicial, but it's sure not close. Her name isn't even mentioned. Richardson's name's not even mentioned in that order. So you don't, what's missing here is both close and also judicial oversight of the decisions. So I'd ask the court to reverse and remand for further proceedings in the trial court.
Thank you.
Thank you, Your Honors.
Thank you both for appearing. This matter will be submitted for decision. Right, the next matter is docket 13, case number 375466, People of the State of Michigan versus Sean Conley. We have one party endorsed for oral argument. Is Mr. DiAgostino?
Good morning. May it please the court, Anthony DiAgostino on behalf of defendant appellant Sean Conley. Your honors, this case is essentially about two things. It's about the scope of consent that was granted to search the vehicle, and then it's about the plain view exception, but more specifically, probable cause or the lack thereof. And with regard to the scope of consent, it's clear based on the conversation between Officer Dykema and Mr. Conley that the scope of consent that was granted was a search for weapons. They have a brief conversation regarding if Mr. Conley has any weapons in the vehicle, and then the officer asks him a very narrowly tailored question, which is, do you mind if I just check and make sure there's no weapons or anything like that? Mr. Conley grants consent to search for weapons. And I would note that I think that the people essentially conceded that issue at the motion hearing on page 10 of the transcript. I think it's lines 15 through 19, where they say that Mr. DiAgostino is suggesting that just because the search is narrowly tailored to weapons, that law enforcement is then required to turn a blind eye to items that are outside the scope. It's not that they're required to turn a blind eye, but unless they have probable cause under the plain view exception, they need probable cause to search or seize an item under the plain view exception. Which leads me into the next point, which is the plain view exception. Of course, probable cause is required to search or seize an item under plain view. And I won't belabor the points that I've put in my brief. I think it's explained there fairly well. But when Officer Dykema notices this test tube in the center console, he has to have probable cause to search or seize that item. So when he picks it up and starts examining it and is learning information about it, and then taps it against the seat to see what the contents do in the vial, that's a search. And he didn't have probable cause to conduct that search when he picked the vial up in the first place.
Well, the court said based on his experience as a police officer, that he did have probable cause to know that this was possibly related to some type of drug activity. What's your response?
Yes, Your Honor, the trial court did rule that. There are no facts in the record that would support that. And I don't think that training and experience just creates a presumption of probable cause. So when he's looking in the console and he sees this vial, and I think the stipulated facts indicate in paragraph 9 that he actually notices the speckling or the residue on the inside of the vial after he picks it up. But when he notices the vial in the console, he's got to have probable cause. And we need some objective facts and some sort of a substantial basis to determine that what is in the test tube is criminal in nature. And he doesn't have that when he notices it in the console because it's obviously not a weapon. And so the weapons are the scope of consent that he was granted, so he needs probable cause to outside of that. Thank you.
Thank you. We appreciate your appearing today, and this matter will be submitted for decision. Docket number 14 is case number 375587, People of the State of Michigan versus Charles Jackson.
Good morning. May it please the court. Jonathan Foreman with the Ingham County Office of the Public Defender. I'm representing Charles Jackson in this matter, requesting that this court reverse the order of the lower court and determine that the admission of the alleged victim's statements in her absence at trial would violate the Confrontation Clause. Although the Supreme Court's test for admission of statements without the ability to confront is anything but clear, application of that test to the facts in this case is clear. My client, Charles Jackson, as you all know, is accused of assault of conduct, and the people seek to admit the alleged victim's statements at trial, even if she does not appear to be cross-examined. The people argue that because Mr. Jackson had fled the scene, he remained a danger to the alleged victim and the police, and therefore he remained a danger to the alleged victim and the police, and therefore the statements were made in the context of an ongoing emergency. That argument is directly contrary to Crawford and its progeny, and it's directly contrary to the Supreme Court's clear warning not to interpret its decision in Michigan v. Bryant too broadly. It's directly contrary as well to Bryant's instruction that an emergency has ended if the assailant flees with little prospect of posing a threat to the public. If this court were to adopt the people's formulation of the non-testimonial exception during ongoing emergencies, in my view, the exception would swallow the rule. This court should decline the people's indication. As the court knows, testimonial statements must be subject to cross-examination if they are to be deemed admissible at trial. The clearest case we have distinguishing between testimonial and non-testimonial is Davis v. Washington. That case interpreted, as the court knows, two different fact patterns. In Davis, a 911 call made while the assaultive conduct was ongoing.
Right, and Hammond.
Right, in Davis 911 call.
What I'm trying to say to you is, this is all in your brief, and trust me, we're familiar with Crawford, Hammond, Davis, and Bryant.
Okay.
That's all that was discussed here, so.
Understood, Judge. And so what I'll just say is that this case, I believe, is directly analogous to Hammond. Because just as in Hammond, the statements were made as part of an interrogation into past criminal conduct. There wasn't an emergency ongoing at the time. The officer was seeking to determine what happened rather than what was happening. And it was a formal interrogation in that the victim was responding to statements or responding to questions and providing answers to those questions that detailed how criminal conduct or allegedly criminal conduct at this stage began and progressed. The statements weren't a cry for help. They did not provide information to let the officers immediately end a threatening situation. And I think immediately is the key word there, because the threatening situation had already ended. So for that reason, I think that our case here is directly analogous to Hammond. It's also directly analogous to Walker, which is a precedent from this court, which the people.
Well, what about the fact that he appeared to be stalking her?
So I think I understand that the facts aren't great. And that the statements aren't great. But I think what you have to look at is what the purpose of the police officer's questions and the purpose of the answers that were provided in response to those questions, Judge. The officer is there for 15, 18 minutes before he asks a single question about where is this guy? Questions that would, in theory, be leading to ending the ongoing emergency if under the people's formulation of the facts of this case, right?
One of the things that you said in your brief is that the people keep insisting that the emergency was ongoing when after the interrogation, the officer simply left the home. Well, that's not what happened, because watching the videotape, what the officer said, it told the occupants of the home is, you know what, I'm going to stay in the area. I'm going to post up around the block for a little bit. Would that bother you if I stayed there and looked out, made sure he didn't come back? Does that make a difference here?
I don't think it does. Because you still have to look at the purpose of the questions that were being asked and the purpose of the questions that were, and the purpose of the answers. So the purpose of the questions were to detail the supposedly criminal conduct that had occurred. He was asking about the relationship between the two. He was asking about the assault. He was asking about how she obtained her injuries, things like that. And then only after 15 or 18 minutes was when he started asking, where might this guy be? Right. So he's getting the information about the supposedly criminal conduct for use and for arrest or for future criminal prosecution. And only after obtaining that information is when he started started asking the questions about where might he be, which would be what the people are arguing is the ongoing emergency, is that he's on the loose. He's out there somewhere. But the officer gathered all that information about the ongoing or about the past criminal conduct before doing anything that would attempt to resolve the supposedly ongoing emergency. And so when you look at the primary purpose test that the Supreme Court has articulated, the primary purpose, at least of all those initial sets of questions, was to gain information for use in criminal prosecution and to gather information regarding arrest. And so I don't think that the fact that he was posted up, if he was posted up around the corner, I think what the people state in their brief that he went to try to find my client, things of that nature. So it's unclear, it's not part of the record, how long if he did stick around, how long he had stuck around for. All we know is that he left the home supposedly in the midst of an ongoing emergency. But beyond that, Bryant explained how courts should approach this distinction in domestic violence situations, and it's narrower than in the situation of Bryant, which was a threat to the public at large. So we look at a threat to the immediate victim in domestic violence contexts when we're analyzing these types of arguments. And the court noted that domestic violence cases have that narrower zone of potential victims, and that an emergency situation or an ongoing emergency ends when an assailant flees with little possibility of posing a threat to the public. And that we have that here because there's no argument, there's no facts to support that my client supported or posed a threat to the public at large. And so because the threat to the alleged victim had ceased at this time because she was safe in a home with police officers, with one police officer and at times two police officers, she was not, the assault had ended, the assaultive conduct had ended. And that's where Walker is directly on point, and that's this court's case. Because in that case, it has similar facts to this case as well, where the assailant had fled, including, in that case also included threats with a firearm, like this case. But the assailant had fled, and this court determined that the statements that were made to police by the victim in the immediate aftermath were still testimonial statements because they described past conduct and because there was no indication of continuing danger. All right, are there any other questions? All right, thank you.
Good morning. May it please the court, Elizabeth Allen from the Ingham County Prosecutor's Office on behalf of the plaintiff appellee in this matter. And obviously this court is well aware of the surrounding case law on this issue, so I'm going to keep my argument to the point, which is that what we have to look at here as to whether there's the existence of an ongoing emergency is a highly context-dependent inquiry. And in this case, there were exacerbating factors that the trial court found, and the factual findings were not in clear error, and we'd ask this court to affirm. This was a domestic violence case, to be sure, but it involved stalking, threats, a firearm, a specific threat to the victim for calling the police, and then the defendant takes off in his vehicle. The threat to the victim had not been neutralized when the police got there. This is not the same thing as in Hammond, where we have a domestic violence case with fists. It's a shared home where the two live there and our defendant flees. This defendant was never supposed to be at this residence. It wasn't his home. The victim got home or came there, and because he had a GPS tracker on her car, he shows up out of nowhere, assaults her, drags her down the street, bites her face, threatens her with a firearm, her life specifically, and specifically threatened her for calling the police, steals her phone to try and prevent her from calling 911, and then takes off again. And so in this case, she doesn't know where he went. The police don't know where he went. He was never supposed to be at this residence to begin with. So the threat in that situation has not been neutralized. And if you look at the context of how the questioning does go with the police officer who arrives, if we're looking at the purpose the participants have in asking their questions and then also giving their answers, the officer is trying to figure out what happened. And the victim is not forthcoming, and the other person who is there is literally yelling at her, tell them the truth so that you will not be killed. And so the officer is, yes, he's calm, but he's asking her information, and as she's giving him more, he's understanding what the situation was, what happened here. Because we have a domestic violence victim who has a clear injury to her face and had just been stalked to this residence. And so as the officer is going through this, he's learning what the threat is and what actually happened. And then he starts asking the questions, oh, do you know where he might be? What's his license plate number? What kind of car does he have? And even at the end says, well, what if I post up around the block? Because we don't know where this man is. We don't know if he's coming back. He had a firearm. And so from the officer's position and from the victims, this is an ongoing emergency, ongoing threat, not the situation where the victim is able to escape and she's gone from her residence to someone else's, like in Walker, where she is a neighbor, she's safe, she's separate. This is a situation that only occurred because of his stalking behaviors and that he was never supposed to be at this place to begin with. She never expected him to be there. Obviously, he attacks her on the scene immediately and then threatens her life for calling the police, which is then exactly what happened subsequent. So we would ask the court to affirm the trial court's ruling.
You know, you keep saying the threat wasn't neutralized, but is that really what the courts talk about? The threat being neutralized, or is it no immediate threat to the? I mean, there's a big difference between the two.
Right. Your Honor, I can, there's some of the case law where they talk about the threat being neutralized to the victim when we're talking specifically about the victim. But in this case, because regardless of which you apply, the stalking behavior and the sudden jumping on the victim and coming back at any moment.
But I mean, this is all on video, and when I watched it, I was like, this is just a gathering of information as to what occurred. There was no sense of immediacy in the officer or her. And as you said, there was a little commotion with the other guy, the guy who owned the house. But it didn't, I don't know, it seemed more in line. I don't know the case names as well as Judge Letica and Judge O'Brien, but this not a 911 type situation.
Right.
It's much more calm and gathering, but
So, can I interject?
sure.
So, it would really be so helpful if, when we're given these videos to watch, that we had a transcript that went along with them. Because I watched it, I'm sure Judge O'Brien watched it as well. And toward the end, the officer, she's asking, so how do I get in touch with you? Because she's got the Find My Phone app. And he says to her at the very end, well, just call 911 or the non-emergency number, whatever. I mean, he's not saying, call 911 immediately. Here's my number, call me, just, or non-emergency. It really does seem to fall closer to Hammond and Davis and not to Bryant. And, for the same reason that Judge Murray detailed, and as you've noted, that it seemed to be information gathering from the victim about it.
Right.
And then at the end, where is he, so we can go find him?
Right. And I understand that. And it is objectively with the video, it shows what it shows. And that's what we're here, obviously, in a de novo review, we're going to evaluate that. But the only other point I will make is that in this case, it was a carte blanche, what you can admit and what you cannot. And I think in the course of that interview, there was not a distinction made as to which statements, if there are some statements that are made for an ongoing emergency situation as to find him versus if it's information gathering.
It might be something different if at the end he said something like, I'm coming back, or don't think this is the last time you'll see me. That kind of thing we might be talking about a different situation, but on this video, I would have to say it's closer to Hammond.
Okay. And I understand that, and I won't keep pushing. I can understand when I can receive those answers from the judges. So obviously we'd ask the court to affirm, understanding the statements that have been made here. Thank you.
Hopefully the victim, you can get her to come to court.
Yes, that would change everything on it.
Yes.
Yes.
That's everything.
I'm not going to take up
The
too much time.
Constitution will be complied with then.
Just a one thing on the carte blanche, because I think that seemed like
You really feel like you need to say
I
something?
understand. Okay, well, I'm going to ask, thank you. I'm going to ask the court to reverse. Thank you.
Okay, thank you.
Okay, next case is docket 15, case number 366477. People of the State of Michigan versus Frankie Joseph Akeley.
Good morning, Your Honors. Jacqueline McCann from Sato on behalf of Frankie Ackley, and I will be dealing with the trial issues. Ms. Sutton has the resentencing appeal. We did also have some videotape in this case. I hope the court received that. I did turn it in at the Detroit branch.
Watch so much videotape these days
Yeah.
between body cams and police interviews.
Um,
As I said, it would be so very helpful if we had transcripts of.
Can I count you amongst the supporters if we frequently think about proposing a court rule that says they have to transcribe them, because currently they don't have to transcribe them, just as an aside. So your honors, we do have a couple related issues in issue 1 and 2 that I do believe are dispositive. I'm certainly ready to answer the court's questions on issue 3 if the court does have them, but I'm going to focus my attention on issues 1 and 2 today. Mr. Ackley's defense was self-defense, and it was eviscerated by the errors in issues 1 and 2.
Well, he got the self-defense instruction, right?
Only because I suspect Mr. Way, when the trial prosecutor came to him, said, "Don't make it worse."
It's lovely to have an appellate division, right?
But it doesn't save them from the errors, because the prosecutor rightly pointed out in her closing argument that the statements that came in through the defense investigator were only for impeachment of the prelim testimony that was read to them, that it wasn't substantive. And without it being substantive evidence, there is no evidence of self-defense. I do believe that the court has to reverse on issues 1 and 2. I do want to point out, I've characterized them as threats, and I think everybody in the courtroom understood them as threats. But I will say that the case law actually only says intimidation, which I think is slightly lesser standard than threats, that the prosecutor can't intimidate the witness. So I believe that that threshold was more than met. And then it wasn't, when I read the transcripts and saw the judge's statement when they were talking about letting Gross's testimony and the investigator's testimony in, it wasn't clear to me that the judge was thinking that it was only coming in as impeachment. And he does make a statement later that indicates he wasn't thinking about it that way. But, you know, under our right to present a defense and Barrera, I do believe there were statements against penal interest as well, should have come in as substantive. I welcome the court's questions, but I feel like Mr. Ackley was denied a fair trial where his self-defense defense couldn't be presented, essentially. And other than that, I'll reserve time for rebuttal.
Thank you. Do you want to respond to that issue, and then okay, thank you.
Good morning, Matt Way from the Jackson County Prosecutor's Office on behalf of the people. Judge Letica, I'm gonna note the transcription piece to maybe our trial attorney, so we put that into the record, because I know our system, which a lot of prosecutors use now, actually automatically generates transcripts on videos. So
Fantastic.
yes, I'm gonna note that with my higher ups in our
That saves me
trial
from
attorneys. Yes, and some of,
rewinding and rewinding and rewinding.
and there's a great video here. Some videos are less great.
Oh, there's a lot of video, yes.
Yes. I want to just emphasize a few things. I think we draw this distinction between different cases on issue 1 causing Mr. Fung to be unavailable. Every case that I'm aware of that I've come across where the court has made that sort of finding, it's a case where the prosecutor is kind of directly speaking to the witness. That never occurred here. In fact, you read the January 6, 2023 transcript, page 4, the prosecutor makes clear that they had a meeting set up with Mr. Fung. They were made aware, and then they said, wait, there's an issue here.
Friday before the Monday trial,
Right. And that was because they had received the report
Thursday.
from the defense the day before. Yes. So
See,
I just had
we
this-
really do read it.
yes, I know. But yeah, my only point was there
Yeah,
was,
the point is, this wasn't the prosecutor talking to Mr. Fung and saying, I'm going to charge you with perjury and or lying to a police officer.
yes.
Instead, this is news to me, and I think he may need counsel.
Yes, and even,
And counsel is the one that tells him, yes, invoke your Fifth Amendment rights and fully invoke your Fifth Amendment rights. We're not even going to do a piecemeal approach.
yes,
And that
absolutely,
that renders him unavailable.
absolutely. Um, the prejudice point, which I don't think the court needs to get to that, but, and this really goes to the first and second issues. You know, I wanted to just emphasize, and we stated in our brief, and I don't want to just rehash that, but we don't have any testimony as to what defendant's belief was here. Ms. McCann's exactly correct. I received a phone call. I think it's probably even in the record. I said,
Okay, so
so even if Mr. Fung testifies that he saw a gun, that does not mean that the defendant saw the gun. And there's nothing in the record that the defendant saw the gun, that he was scared, anything like that. So there just simply was no valid basis for which a jury could have reasonably found self-defense in this case. The last thing I just wanted to
I
mention,
think it's clear from your record that the jury watched the videos.
yes, and I think the video was played like 50 times during the trial.
Yeah.
On the third issue, the ex parte communication, certainly we believe that this was not a substantive communication. And so I didn't address kind of the prejudice point, but I just wanted to point out that even if the court found that that was a substantive communication, the France case makes clear that one of the ways to rebut that presumption, the presumption of prejudice is, and this is page 163, footnote 34, quote, is showing that the trial court had expressed its intent to communicate with the jury and counsel had given prior consent to the communication as well as to the substance of the instruction, which I think is exactly what occurred here. Defendant kind of argues that the judge went in to the jury room without the court officer. I don't think that's at all clear from the record. In fact, I think one of the comments by the judge was, all right, I said on the record what I was going to do. I'm going to go do that, even though defense counsel wasn't present at that moment to agree to it. So I'm happy.
What's the rule of 12?
That's a good question. And I would honestly, I would have loved to have an evidentiary hearing to make this record clear.
Right.
There was a
There
motion.
wasn't a request for.
There was a motion for new
Yeah.
trial. We could have addressed all of this. I would have stipulated to that. I think it was him, it was the judge saying, all 12 of you have to be present to deliberate. That's my best guess.
Did Judge McBain retire?
He is still there. No.
He's still there,
Yep.
okay. All right.
Yep.
All right, so what about the fact, what could it potentially, well, here, we're speculating because I would think that you'd have to explain. You've now lost a juror. It wasn't even clear to me from this record as to whether they'd even begun deliberation or not.
Right. The record isn't clear. What it's, the way I read the record is that the initial jury deliberated. Then you had somebody drop out. You brought in an alternate juror.
Well, it seemed to me the only thing that they did was talk about timing.
Right.
At the end of the day, do you want to come back the following day or what's?
And so I think to that point, you don't even
You
have.
don't know.
Yes, he's not even communicating with a deliberating jury, which
Right,
is
and
the
the-
requirement.
12th juror didn't show up, so they had to wait for the alternate to come in. But it clearly at some point they decided they wanted to see the videos. I don't.
Yes, I would have loved to expand the record in this instance, but are there any questions that I can answer? All right, we would just ask the court to affirm Mr. Eckler's convictions. Thank you.
Thank you.
Couple brief things. When the prosecutor is talking to Mr. Fung's attorney, I think Mr. Brandt, and telling him, we're going to charge him with perjury if he gets on the stand. Mr. Brandt is the agent of Mr. Fung, right? So they're saying that to the witness because they're saying that to his attorney. So it doesn't remove it from the intimidation because it goes through his attorney. Would be one point I would make. I know Mr. Way to be a straight shooter, so I'm now questioning my own recollection in my motions for new trial and at motions hearings. I normally put if the court is not convinced on the record, then give us an evidentiary hearing. So I would just ask the court to see if I did that. But I do know that in the request for relief in the brief, I have asked this court if there are any factual questions that would are open that we need to fill in order for us to get to relief, to remand for an evidentiary hearing under People versus Jackson. I know there's a ton of People versus Jacksons. It's a Michigan Supreme Court order that it says that making that request in the request for relief in the brief on appeal is a proper motion to remand. So thank you.
I realize I forgot to call the second case number for this docket, which is 373633. Thank you. All right.
Good morning, Your Honors. Laura Kathleen Sutton for Frankie Joseph Ackley. And I will be brief, as the panel has read my brief. However, I would reserve a couple of minutes for a possible rebuttal. As to proportionality under People versus Posey or People versus Milborn, Mr. Ackley received a sentence at the top of the sentencing guidelines for his first felony conviction. Now, I agree, second-degree murder is a serious offense, but the guideline range was 15 to 25 years, and the probation department recommended an 18-year sentence. The trial court judge or the resentencing judge, Judge Jordan, said that she found no mitigating factors. However, the mitigating factors were there. Although Frankie Ackley possessed family support, he came from a broken home. He was raised primarily by his grandmother. He suffered as a child from ADHD and learning disabilities. He had a speech impediment. He was born with a hair lip and cleft palate, which left him with a facial deformity, which left him stigmatized and picked on by his peers. His prior record consisted of adult record consisted of 3 misdemeanor offenses, the most serious being assault and battery, for which he received 7 days in jail and completed a 12-month probation period. Mr. Ackley is not a career criminal, and the maximum guideline sentence was not warranted in this case. Now, as to the argument on OV3 scoring, I will rely on Ms. McCann and my argument in our brief. Preservation of this issue is our goal.
Right.
This court cannot overrule Supreme Court precedent, but some encouraging dicta would be appreciated. As to OV19, again, I stand on the argument presented in my brief. Leaving the jurisdiction for your home without more should not justify the scoring of 10 points. In response to the prosecutor's assertions, Frankie Ackley moved to Iowa following completion of his district court probation in 2018. He took high school classes online and was given a diploma by the Da Vinci Academy in Jackson. Post 2018, he made his legal residence in Cedar Rapids, Iowa, where his father, stepmother, and step siblings reside. He did not change his name or his appearance. He returned to Michigan in late February of 2020 to take part in a roofing job working with his uncle Joseph in Jackson. And on the date of the offense, March 6, 2020, the job was complete and Frankie Ackley returned to Iowa. When he became aware that Michigan authorities were looking for him, he contacted attorney Michael Mataloni of Lansing to assist him with his surrender. However, that process was not completed when he was arrested by U.S. Marshals in Iowa. He did not resist, he did not fight extradition, and attended all judicial proceedings. In addition, the fact that he disposed of a firearm does not require the scoring of OV19. If it did, 99% of all criminal defendants will be scored under this variable. OV19 should be scored at 0 points. This scoring would lower the guideline range from 180 months to 300 months to 162 months to 270 months, requiring resentencing. And as I stated in my brief, if the circumstances surrounding his attempts to surrender himself or the extradition process, should it be an issue, we would welcome an evidentiary hearing as well. And I see some talk this morning about a potential evidentiary hearing in this case, and that could be part and parcel of that. But obviously OB-19 should be scored at 0 points and Frankie Ackley should be resentenced. Thank you. Any questions for me?
Good morning again, Matt Way, Jackson County Prosecutor's Office on behalf of the people. I don't have anything to add to my brief on the resentencing unless the court has any questions. No. All right.
Thank you very much.
Thank you.
Thank you all for appearing today. This matter is submitted for decision. All right, the next matter is docket 16, case number 372917, Sharice Buchanan versus the Department of Transportation.
Morning, Your Honors. Mike Dittenberg, Assistant Attorney General on behalf of the Michigan Department of Transportation. This is a highway exception case involving a parallel parking lane. In Yono, the Supreme Court held that parallel parking lanes are not travel lanes that fall within the highway exceptions, duties of maintenance and repair. The lower court, the Court of Claims here, held that there was a question of fact regarding the highway's design. That ruling was an error because there are no questions of fact here. There are no disputed facts. The only question is the legal effect of there not being pavement markings delineating the parking lane from the travel lanes at the time of this incident. So in essence, the Court of Claims ruled that pavement markings are dispositive as to an agency's evidence of design. Nothing in Yono or the highway exception requires that result. And once we get past that, there are no disputed facts. This case is vastly different than the unpublished opinion in the Pitts versus Dearborn case that plaintiff cited, where there was evidence submitted by the plaintiff to show that there was use of the entire paved area as possibly a dual use lane with Amazon trucks, school buses using it from curb to curb. There's nothing here there's no such evidence here to.
Wasn't this location, the same location involved in Bullock Pickens back in 2020?
It was, Your Honor, and I believe you're right.
I mean, the exact same spot in front of the same stores, right?
Same store?
Yeah, same affidavit or affiance.
Exactly, and the Court of
Right.
Claims on the same evidence held that
Right.
this was a dedicated parallel parking lane. And
Right.
nothing's changed since then to suggest that it's now a dual use or some other lane. So I'm happy to answer the court's questions, but otherwise, this was almost decided like a C8 motion, and really it's a C7. The department met its burden of proving its design, and there was no evidence in response to raise a factual issue as to the design intent of this parallel parking lane. Thank you.
May it please the court, my name is Todd Stern, proudly appearing on behalf of the plaintiff appellee here. I'm not going to spend a lot of time on this. Yono got it wrong. It was a different court. It was the Markman Court. We have a different Supreme Court. If you look,
That's your argument?
well, if you
The
look,
justices have changed, and so therefore we should make a different ruling?
it's not necessarily that extreme, Your Honor, but
Well, that's, you started off your argument that way.
right, because if
It's
you read,
offensive.
I don't mean to be offensive, but if you read Justice McCormick's dissent in the Yono case, that's basically what we're relying on.
Well, then you
She's
argue-
right.
Then you argue that Yono is wrongly decided, not who the authors of the opinion were.
It's
mean, that-
wrongly decided for the reasons stated in Justice McCormick's dissent. She's very articulate, much more articulate than I can be here. And I apologize if you were offended in any way by that.
It's not personally, it's just, the statements like that is what, that makes people look at the courts in a political way. And believe it or not, we really try not to act that way. We put our heart and soul into this job. And then to have some lawyer come up, who I know, Mr. I know about you, you're a respected lawyer, you've been around for a long time. And for you to say something like that, it's just not right.
Again, I apologize, Your Honor. I think my point was that we can see the Supreme Court going a little bit different direction
Which is fine.
on some of these tort issues and
Right.
governmental immunity issues. That's all. That was my only point. So I didn't,
And-
if it
and
came
way-
across
and
the wrong
to
way.
do that is the way that last council did it. I understand that you're bound by the Supreme Court authority and you cannot give me any relief here and you know that I'm just going up. That's fine, but to come here and say that,
Yes, I phrased that horribly. I apologize, Your Honors.
and the affidavit here was very clear and in my view, undisputed below and, you know, Judge Murray was on the prior case. It is the exact same location. It is the exact same affidavit. There is no reason that the outcome should be different here.
We didn't have an opportunity to do any discovery in this case. This case was decided. The motion for summary was filed in lieu of an answer. So I had zero opportunity to do anything. I don't know if the markings on the road were the same as that prior case. I don't know anything about what changed between 2020 and this incident. So I respectfully disagree with that just a little bit because we didn't have an opportunity to develop any factual basis for anything here. So, and again, I think if you read Justice McCormick's dissent,
All right,
Judge
but
Krause
we're-
also.
We're bound by what the Supreme Court majority did in, you know.
Judge Krause also in an unpublished opinion called Gentry versus State also asks that the Court of Appeals and ultimately the Supreme Court reconsider the Ono case. So I would just point out that there's been.
You're free to do that.
Very good, Your Honors. That's all I wanted to say.
No rebuttal, Your Honor.
Okay, thank you both for appearing. This matter will be submitted for decision. Okay, and I believe that completes our 10 o'clock docket. We'll take a short break at this time.
Please be seated.
Calling docket number 17, case number 374176, Richard Mallard versus Stacy Mallard.
Good morning. Trish Haas appearing on behalf of the appellant, Stacy Mallard, and I also have my associate present, Kelsey Knapp, who has been very helpful to me in all of my appeals, so I wanted her to be introduced to the court. Well, I have an easy case for you for a change, and I think you'd probably appreciate that because appellee has
There's agreement.
there's agreement.
A lot of
Wow,
agreement, yeah.
I know. So I'm going to just skip over all those issues and really focus on the only two issues really that are contested. This first is the issue of spousal support. And I will just, well, that's the most important issue. So let me speak about it. I wanted to talk about the fact that, and I know you review a lot of orders, Judge O'Brien, but at the onset of this case, this appeal was actually dismissed for a basis of lack of jurisdiction because the issue of spousal support was reserved. I filed reconsideration explaining why it should still be an appeal of right despite the fact that spousal support was reserved. And you agreed with me along with the panel, the other two judges, and reinstated the appeal. And the reason I bring this up is because I think this is a very important issue. And since all the other issues are really resolved, and spousal support is not, I wanted to take the time to first explain that I think it is important for this court, in its opinion, and perhaps consider publishing it, that a reservation of spousal support does not bar an appeal of right. Because routinely, unfortunately, it's getting dismissed. And the reason why it should always be an appeal of right when spousal support is reserved is because the court rule, MCR 3.211, and this wasn't in my brief, but it is contained in the motion for reconsideration, all the case law that I'm talking about. But 3.211B4 specifically states that a trial court must, in its judgment of divorce, either enter a provision, if it doesn't award support, it has to enter provision either denying or reserving the issue of spousal support. So since the court rule allows a trial court to reserve spousal support, that should not bar an appeal of right. And I think it's also important to point out that a reservation of spousal support is not a determination that spousal support may be, it's only a determination that the award may be revisited in the future. It won't be a retroactive award to the date of the judgment. And in fact, many cases, in many cases, and Boyd v. Boyd and Valentine v. Valentine, not Valentine, but Valentine, actually state that exact premise, that it's an award, that is a statement that spousal support is not currently being awarded, but that it may be awarded in the future. And the issue with that is it may be awarded. So it would cause absurd results to not have a determination that a reservation of spousal support is still accrues an appeal of right, because otherwise litigants may never accrue an appeal of right, because you have to wait for a ruling on support. So I really would like to, since the issues are easy, I wanted to take the opportunity to talk about this. So perhaps it can be a part of the opinion and order as well in this matter, so that there won't be any confusion in the future for other litigants. Now, that ties into the issue in this case with spousal support. Here, the trial court did reserve it. I explained in my brief, and do you have a question, Judge O'Brien? I didn't want to
No.
keep talking. Okay.
You're fine.
You know, this is a case where spousal support clearly should have been awarded. It was a 16-year marriage. There was a significant disparity in income. Mom was a stay-at-home mom. The earning capacity, mother was primarily a stay-at-home parent throughout the marriage. And I wanted to address that because appellee has argued that mom did nothing but rest on her rights and didn't file a motion. Well, importantly,
Well, wasn't it, you said it was reserved though, right?
reserved.
And it's getting remanded back anyway, right, on other issues, so
Yes.
can
So
it just be raised then?
well, the problem with, I wanted to be clear that the reason why a reservation was not appropriate is because a reservation, sorry, tongue twister, a reservation will not make the spousal support award retroactive to the date of judgment. It will only be an award moving forward. And that's what Valentine v. Valentine
Okay.
says. So that's why I tied these in together, why a reservation shouldn't bar an appeal of right, and also subsequently.
No, I'm sorry, I thought you were, maybe I thought you were arguing about why your client's entitled to spousal support.
Well, I did put that in the brief just to understand that there should have been an award at the time. Like I said, a reservation is for future adjudication.
Right, I get that, yeah.
So I just wanted to point out
Okay.
that reservation was not appropriate because this was a case where spousal support should have been awarded. But I know you're not fact finders, of course. I've been doing this too long. But of course, I didn't want to say it was harmless error.
Right.
Because it's not harmless, because a reservation is an award in the future. It's not a determination that spousal support should be determined as a date of judgment. So that's why I wanted to explain why spousal support was appropriate at the time of judgment. Okay, all right. The only other thing that the trial court did not rule on the issue of gymnastics fees, which was substantial. It was $20,000 a year, and mom requested that they be.
Right, again, we're remanding.
You're remanding. Okay, no problem. So the only other thing that I have to say, and I guess I can do rebuttal, reserve 2 minutes, which I didn't request, but I'd ask that the court include a provision that costs can be taxed, because absent your provision, absent a determination in the opinion, it's been really difficult to get tax costs by the clerk.
Gymnastics are $20,000 a year.
Yes, I know.
That's a lot.
Well, hockey is probably more expensive than that,
It
right?
is?
I think.
It wasn't, well, it was a long time ago when my kid played.
I think it
hockey,
is.
so-
Yeah. Does anybody have any?
It's two people though, right? It's two,
Yes,
two sisters. That's-
yes.
Oh, okay.
Yeah. Still
I mean,
expensive.
10,000 is not a
No.
drop in the bucket, but.
Inflation, everything is more
Yeah,
expensive.
right.
Do any of you have any questions? Okay, thank you for indulging me about the issue of reservation. I appreciate it.
Good morning, Your Honors. Jordan Ayler Smith on behalf of the appellee father. As Your Honors are very well aware, I agree with the majority of Ms. Haas's arguments. I will say on the property division, I think we disagree a little bit in terms of the scope of the remand. I think when we are talking about the property division, we're not talking about the potential to reopen proofs or anything like that. It's simply just a remand for the trial court to put its factual findings on the record in support of the trial court's property division decision. In terms of the spousal support argument, I mean, as we say in our brief, respectfully to sister counsel, if mother needed that support for her own support at the time the judgment was entered, she could have done something about it, and she didn't. The trial court set a review hearing for January 2025 for after the marital home was supposed to be sold. That review hearing was canceled, and as far as I know, nothing's happened since. In terms of the fees issue, as you pointed out, Judge Letica, that's something that certainly can be dealt with on remand. I think it's relevant in the child support decision, which obviously is best left to the trial court. So unless your honors have any questions for me, I will happily sit down.
No questions. Thank you.
Thank you.
Just briefly, it was the trial court who sua sponte canceled the review hearing that was scheduled for January 27th, 25th.
Okay.
Okay, it was not us. I didn't want any blame to be put on
Agreeing.
mother.
Yeah.
And the only other thing about property findings is they're putting the cart before the horse. Clearly, there has to be findings before a
The
determination.
value of the property?
I'm sorry.
Yeah. Was there something about the values of the property?
Yeah, the values and
Yeah,
also,
or just
yeah,
be-
it has to be remanded. We can't just remand it and say you get the same award because there's no findings. That's all I have.
All right,
Thank you.
Thank you both
Thank
for
you both.
appearing. This matter is submitted.
Have you,
for
how long have you
decision.
been working on appeals?
Since, August 23, since I started working.
Okay, so have you argued here then?
Just the briefing.
Oh, well, hopefully soon.
I'm preparing her. I was thrown into the wolves and I know that's, how a lot of people are trained, but I
Yeah.
did it personally. So I didn't want to do that to her. I was trying to be kind and nice.
Well, when you get a good, nice panel like this one, then you should send her to
I
us.
should have. You're right.
Yeah.
I should have. You're absolutely
But you
correct.
never know, anyway, yeah.
I know. No, you're right. You're right. The last
Anyway.
panel I had, I will remain nameless.
Yeah. It would not have been
Well, it
good.
wasn't any of
Right,
us,
Terrible. I
okay.
did it to her.
right, exactly.
She had 3 cases in one day, so it was just. It was
Yeah.
a lot
Oh,
of
maybe I
factual
was on that.
issues. It was
Maybe I
insane.
was there that day.
You were there that day,
Yes.
but it wasn't you that I was speaking of.
Oh, sure it wasn't, sure.
It was the mid judge who just immediately told me that I was wrong about everything and
There was a
it was a new case.
Right.
case that just come out after briefs have been submitted.
Oh,
Yes,
yes.
and I didn't know about it and
Yeah.
in 20-something years of practicing appellate work, I never had that happen and I guess the bottom line is you're always learning something new. It doesn't matter how long you've been.
That's
doing it.
right.
True, that's
That's
correct.
true.
That's
Yeah.
correct.
Well, good luck.
Yes,
Have a good day.
thank you.
Lesson submitted.
Yeah.
Thank you, I appreciate it.
Yeah, you're ready. I'm gonna throw you the wolf scene.
All right, I'll see you.
Very nice all the time. I don't know that I've ever had a bad experience arguing.
Well, that was just,
I've had bad experiences watching other people.
Yeah. Oh, my God, I was nervous. What happened before that made me nervous that the prior.
Come on, what
I
you
know,
said was
it was
ridiculous.
so inappropriate.
Yeah.
I gasped as he said it and then it really made me nervous because when you watch one of your colleagues make an epic mistake like that, it makes you nervous.
Yeah,
I mean, I don't know how you recover from that.
I'm not sure he's too
I'm
worried
sorry, Your
about
Honors, and you walk away from the podium.
Yes, that's,
it. Right.
yeah, just hide under the podium. That would have been a good choice.
Yeah, all right, well, have a good afternoon.
Take care.
Thank you.
As I recall, you recovered quite well from that, but
I'm sorry, what?
as I recall, you did respond.
I did,
Yeah.
but if it was her, I would have felt terrible. I would have,
Yeah,
Yeah.
I don't like to throw people to the wolves.
Oh, yeah.
I want people to feel confident and secure before.
yep.
I'll see you guys soon.
All right.
Yes, you will.
Uh-oh.
Thank
But don't-
you.
but
Take
don't-
care.
But don't say you guys when
Don't
you're
say you
here.
guys.
I
Don't,
Right.
Yeah.
see, we're just talking
Not
about.
ready yet, not ready yet. Gotta do some practicing.
Take care, thank you.
All right, the next matter is docket 18, case number 375479, Inree Scroll Minor, and case 375485, Inree Dunn Scroll Minors. Oral argument has been waived on both cases, and this matter will be submitted on the briefs. Docket 19 is case number 376337, Inree White Minor, and oral argument has been waived. Is there another one? Thank you. Also docket 19, case number 376338, Inree Parsons Minor. And 376545, Inree Parsons Minor. All 3 cases will be submitted on the briefs. And finally, Docket 20, case number 376295. Stephanie Meyer versus Michael Meyer. There is no oral argument, and that matter is being submitted on the briefs.
Set another record.
And